1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်811 The Bank of Communications Plaintiff vs KHIN Company Defendant ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Regular Suit before ဦးကျော်စံဦး Judge The Bank of Communications Plaintiff vs KHIN Company Defendant Code of Civil Procedure Order 6 Rule 17 Amendment of pleadings at any stage of the proceedings whether proposed amendments to be underlined in red ink principles for guidance in allowing amendments held under Order 6 Rule 17 of the Code of Civil Procedure the court may allow at any stage of the proceedings to amend the pleadings. It is discretionary depending upon the circumstances of each case. It would have been more convenient if the amendments were underlined in red ink in the relevant paragraphs of the proposed amended written statement so that when the two written statements were compared, one would see at once what was amended and what was not. The principles for guidance are no amendments shall be allowed a. Where it is made at a stage when it will cause injustice to the opposite party or where it would necessitate a de novo trial b. Where it would change the defense completely thereby implying that the application is not bona fide c. Where there was no possibility of misconception of defense at the beginning, but on being unsuccessful in the case originally put forward, attempt is being made to change the front and seek to be successful on another and completely different ground. Mathaintin vs. Unyan and 4 others 1953 BLR 260 AC refer to Uso Tai Lang for the plaintiff, U A Mao for the defendant, U Jiao Zhan U, judge. The sole issue now remains in this suit to be decided is whether the promissory note date 9 July 1954 Exhibit A was executed for consideration. I have dealt with the facts of the suit and other issues in my judgment date 13 March 1966 under Section 118 of the Negotiable Instruments Act. Every promissory note is presumed until the contrary is proved that it was made or drawn for consideration. The burden of proof therefore lay very heavily under Section 102 of the Evidence Act on the defendants to prove the contrary. Uba La, the managing partner of the defendants, alone gave evidence and closed the defense on 21st June 1966. When the suit was called on 1st July 1966 to hear the final arguments, the defendants filed an application for leave to amend their written statement, to which the plaintiff objected. The court had the arguments on the question of amendment on the same day and fixed 7 July 1966 as requested by the defense to hear the final arguments in the suit. In this judgment, I shall first deal with the question of amendment. I must at the outset point out that this application for amendment of the written statement was filed at so late a stage at the conclusion of the trial and when it was faced for final arguments. It is true that under Order C, Rule 17 of the Code of Civil Procedure, the court may allow at any stage of the proceedings to amend the pleadings. It is discretionary depending upon the circumstances of each case. This is not a case of mere formal or technical amendment, but a substantial alternation of the defense. The court had difficulties for not being able to visualize easily what amendments were made or desired by reading the proposed amended written statement. It would have been more convenient if the amendments were underlined in red ink in the relevant paragraphs of the proposed amended written statement, so that when the two written statements were compared, one would see at once what was amended and what was not. In the proposed amended written statement, also the execution of the promissory note, Exhibit A, was not denied. The contention was there was no consideration, but at the same time, it was stated that the amount borrowed was paid off on 9 August 1954 and the debt had been discharged. The defense is self-contradictory, though the defendants were silent as to the notice of demand made by the plaintiff in their original written statement. They deny the receipt of notice in their proposed amended written statement. The demand made for payment was taken as admitted by the defense under Order 8, Rule 5 of the Code of Civil Procedure. Again, though no fraud or undue influence was originally pleaded, they put a new defense in the proposed amended written statement that the representative of the plaintiff made him, Ubala, sign on Exhibit B, which is an agreement promising to pay a time-bound debt under Section 25(3) of the Contract Act by using undue influence by giving alcoholic drinks. I have dealt fully with Exhibit B document when I was answering the issues numbered 2 and 3 in my judgment, date 13 March 1966. It is not therefore open to the defendants to raise a totally different defense in connection with Exhibit B document in the proposed amended written statement. The principle for guidance in a case of this nature are: no amendments shall be allowed, a. where it is made at a stage when it would cause injustice to the opposite party, or where it would necessitate a de novo trial, b. where it would change the defense completely, thereby implying that the application is not bona fide, c. where there was no possibility of misconception of defense at the beginning, but on being unsuccessful in the case originally put forward, attempt is being made to change the front and seek to be successful on another and completely different ground. I agree with the learned judge in Mathain versus Unyan and 4 others when he said, it is an accepted principle now that leave to amend would be refused when the amendment seek to introduce a totally different new and inconsistent case, and the application is made at the late stage of the proceedings. In that case, also evidence was led and the parties had closed their respective cases and the amendment of the written statement was sought only when the arguments were to be had on the remaining issues, pleading estoppel, which was an entirely new defense, not pleaded in the original written statement. For all the reasons given above, I have no alternative but to reject the application for amendment of the written statement, and accordingly it is rejected. Now I come to the issue in question. I must say the defense has failed miserably to discharge its burden of proof in the suit. Burma Law has stated in his evidence that he did not receive cash from the plaintiff on the spot. He said he was in custody and only when he was released from prison, he found the papers showing that he had paid up on 9 August 1954 the loan of jet 75,200 taken from the plaintiff. He deposed that he had altogether paid jet 18,062 3 pias, since the amount claimed in the suit is jet 85,934 65 pia. I must say that he did not sufficiently explain the difference in the amounts. Burma Law is a businessman and he has studied English up to 10th standard. He did not deny the contents of the original written statement. It is hard to believe his evidence that he was in custody and could not get the relevant statements of accounts showing the repayments made by him. When the first written statement was filed, this written statement was signed and verified by him on 25th September 1962, and the record shows that he was arrested by the BSI in connection with an offense only on 21st July 1964. There is no other evidence except his own to support the defense. I answer the issue in the affirmative. In the result, there shall be a decree against the defendants for payment of jet 85,934 65 pia with all costs of the suit.